All right, hi everyone. Shh. All right, how's everyone doing? Good. Yes, good. Now you got the drill. Good. Everyone have a nice long weekend. Yeah, this is a short week. You only see me once. This won't happen again, I promise. Enjoy the respite while you can. Before I get started, if you're interested, I mentioned last week there's a federal society group. It's a group on campus. There's a lot of debates and discussions. Immediately after this class, at 12:20, on the 6th floor of the library, we'll be doing a Supreme Court roundup. We'll be talking all the good cases from last year. It's going to be me, Professor Rocky Rose, who you may have already met, and also Ilya Shapiro from the Cato Institute, who actually might be stopping in this class. He's a good friend of mine, so he might be coming in. So right after this class will be free food. I promise we'll be studying these cases in con law this semester at some point, if not with me, with someone else. So I highly recommend you come, and it'll be a good discussion. Ilya, Rocky, and I, we've done this about 3 years in a row now. It's always a very good show. We put on. It's going to be entertaining. So Ilya and I, we have a very good rapport. Okay. All right. Before we get started, I'm passing around the roll. I also have this, which is a sheet with all of your names on it. See, it's fancy, right? If you haven't given me, if you haven't written your name down, talk to me so I can put your name on the sheet, because otherwise I won't know who you are, and that gets embarrassing for both of us. So I will try my best to keep track of who everyone is. All right. Any questions, anything on your minds, anything lingering, anything bothering you about foxes or people eating each other, or that's about what we've covered this year, right? Anything? No? Okay. All right, then let's get started then. So last class, we discussed, among other things, the INS versus AP case. This was the case involving, remember, one newspaper would steal the headlines of the other newspaper. They would go to the billboards and copy down the headlines. They would bribe the reporters and try and steal their stories and then publish them at a different newspaper on the West Coast. And the court in that case said that there was actually some sort of a property right in the news, right? Not the fact that news happened. The property right was the fact that someone took the time to write down the news, make a story out of it, and then report it. And that was something which the court in that case wanted to protect. Okay? Today's class builds on that. But instead of talking about property in something you build external to yourself, like an article or something like that, we're talking about property inside yourself, your own property. And if you think about the progression of this class, we've kind of been building up to this very gradually, right? What do we start with in the very first day of class? Acquiring land, right? The biggest thing in this entire class is land. How do you acquire land from nature? Okay. Then we started moving a little bit more. Okay. So assuming that no one owns the land, what about things on the land? Whales, right? Ducks, foxes. How do we hunt these different things? Okay. So then we keep building, and then last class we talked about making stuff, right? Writing an article, making an invention, writing a story, making a painting, whatever, right? These are all different forms of property we protect outside of ourselves. Today, we're talking about property inside yourself, property inside your body, property of how people might perceive you. Okay? Now, a lot of this, you might say, whoa, whoa, whoa. This isn't really property class, right? This is like privacy law, right? You're probably thinking, why are we doing this topic in property? Well, let me tell you something. Our modern-day privacy law evolved in part based on notions of property rights. Okay? The same way that judges looked to, animal law to figure out oil and gas rights. So, oh yeah, oil is like a mineral running around. When privacy first started to become an issue in the 1800s, where did judges look? To property law. So this might not have dawned on any of you. It didn't dawn to me till law school. But imagine life before the camera, right? And then imagine life after the camera. Now it was possible to actually capture someone's image instantly and preserve it and duplicate it And this was a scary thought. At one point, people actually feared that this would actually steal your soul. There was actually a legitimate fear of cameras. The Eastman Kodak company was actually somewhat feared. But why were people so afraid of these early day paparazzis? And there have been paparazzis for everyone knows paparazzis. People take pictures of celebrities, right? I don't assume anything in this class. So why were these people so afraid? Because people wanted their own stuff to remain private. Okay, and this topic is especially salient. I couldn't have picked a better week to teach this with the recent leak of photographs of many nude celebrities. I'm sure you've seen this, and if you haven't, I'll give you some practical advice. When you put something on your phone, there is a very good chance someone else can get it. Right? Okay, everyone knows this. A lot of people had some pictures on their phones, and those phones were hacked, or their cloud services were hacked, or various other things, and they were tried to be used for blackmail and extortion, and now they've been all over the internet. Okay? So think about, for a second, oh, it's property one, yeah. Think about this for a second, right? Thank you. Funny story, I think this was last year. I usually teach property 1 in the morning and property 2 in the afternoon. It usually works out like that. It's just very easy for me to keep track. But one year it was flipped. And I walked into class, and I was about 5 minutes from teaching the wrong class in the first day. I was about to go into property 2 in the property 1 class. And then, thankfully, I saw one guy who had come to my office before and asked me a property 1. I was like, wait a minute, no, I know that guy. So I changed it with like 5 minutes. But I got this. All right. So no, this is property 1, I promise. So think about it this way, right? And this relates to the Moore case. When someone takes a photograph of you, right, what happens then? Do you have any claim to that photograph? Can they sell that photograph without your permission? If they take that photograph of you secretly, you know, people have cameras everywhere, on the Google Glass, whatever, right? They take a photo of you privately. Then they make money off of that. Okay. What's your injury? Was the injury the initial photograph being taken of you, or being transmitted, or being transmitted every single time someone downloads that picture? Right? Should that be a crime? Does someone go to jail for taking these pictures of you? Okay. Now consider a different scenario. What happens if you take a picture of yourself? Selfie, everyone knows what that is, right? Okay, you take a selfie, and then you send it to someone you think you can trust. That person turns out to be a jerk, and then blasts it all over the internet. Does that change the calculus? Did you relinquish your privacy because you shared it in the first instance? Right? If you give someone a picture voluntarily and then they go and sell it, or perhaps worse, they threaten to put it on the internet unless you give them money. Okay? These are all issues of what property rights do we retain in our own body, in our own likeness, our own images. And I encourage you, if you want, to take a class in privacy law. In torts, did you cover the privacy torts? I'm hearing yes and no.
Yeah.
So you'll be doing it this year, right? Okay, fair. So you'll do the privacy torts, but I encourage you, if you find this interesting, take another class in privacy law, and you'll find there's a lot of grounding in property theory and how property rights work. Because at heart, whenever a court says you can't distribute that picture, or if you distribute that picture, you need to then pay the subject of the photograph, they're effectively asserting a property right. The same way that the INS court created a property right in the newspaper article, what these other courts are doing is saying, you know what? When they take a picture of me, I retain work because I'm me. I built this reputation. I got dressed. I did my hair, whatever, right? I made that image work, and I retain some right to that. And any profits that come from it, I should get a cut from it. Okay? Right? But there's a slightly different twist to it, and here's the twist. With the newspaper article, right, the person went out, they reported it, they did stuff, right? They went to the front lines. With me, what did I do? I just smiled, right? I just took the picture. Why is it that we as individuals, we as people, have this essence, this entitlement to a property right for ourselves, right? You know, could I go and start dressing like that guy and doing my hair like that guy and pretending to be him? Anything wrong with that, right? People might think that's odd, but am I using his image unlawfully, right? What is it about ourselves that we find so inviolable that we want to protect? Okay, and that's the theme of this class. Actually, I like this class. It's a little bit different, but it hits on other areas which you might not think are property, but really, really are. Okay. All right. Questions before we get started? Nothing. I know you have thoughts, but I'll let it go for now. Maybe they'll come up later. Yes, ma'am. A little bit louder, please.
Is it only economic, like the only reason why you're protecting interest for property for your likeness, or are there reasons why you want to do that?
Ah, okay. So her question was, is the only reason why we're protecting likenesses for financial? Are there other reasons? Well, you tell me. What do you think?
I would think that if somebody else was doing it in a way that
Ah, okay. So I'll give you a little preview, and you're going to do this in torts apparently this semester, but I'll give you a little preview. Oh, you Professor Field, who do you have? Shelby more? Or? Oh, you have trees. Okay, so you'll do these, okay? All right, so you know about the restatement second of torts, right? You know this book exists, right? Okay. So yeah, you're aware of it, right? So this is actually a totally true story, and I tell this so people know how clueless I was. When I first started law school, I didn't know what the heck a restatement was, right? So I walk into class the first day of contracts, right? And the syllabus says there are two books. There's a contracts case book, and then there's a restatement of contracts, right? Or the restatement of contracts, right? So the professor didn't specify in the syllabus which book we had to read from. He just said page 1 through 30. So this guy, right? I read the first 30 pages of the restatement of contracts, and I outlined going, what the hell is this? This doesn't make any sense. Where are the cases? Like it didn't dawn on me that I was reading the case book. So then I walk into class, and like no one had the restatement book open. Oh crap! And everyone had their case book going. Oh god, I'm screwed. So I actually sent the email, a professor email. It's like I read the wrong book. He never replied, but I still have the email. I'm thinking, okay, I have no idea what I'm doing. It's like, okay, I'm unprepared on my first day of law school. But then, they start going through a case. I forgot if it's a case. Think about selling a horse. I forgot which. You can probably know the case, right? Selling the horse. I can't remember what it was. And then he's asking some questions. He goes, okay, so what are the elements then of a contract? Oh, wait a minute. I got this. Because if you just read the case, you could maybe pluck out one element from this part of the case. You can try and figure out, offer, acceptance, whatever, formation. But I'm like, section, whatever. I knew this. I was like, I got it. Offer, acceptance, boom, boom, boom. He's like, where'd you get that from, Mr. Blackman? I was like, oh, well, restatement section, whatever. 1. I don't know what it was. He's like, well, so he goes over to his book. He's like, that's right. I'm like, okay, got it, yes. And that was my first 5 minutes of law school. So I always ask, people know what the restatement is? Yes, now you know. Okay. So in the restatement, this was actually codified by a guy named Prosser, who was cited several times in the article. You probably saw his name. He was a prominent law professor in California. And he basically codified these 4 privacy torts. And because Ashley asked, I will give them to you. Okay? So the first one is called intrusion upon seclusion. And what does that mean? All right? It actually means what it says. If you are in some sort of private place and someone butts in, you've committed a tort, right? This is actually different than a trespass. Oh, isn't this just trespass? This is actually a little bit more. In a place where you might have some sort of privacy and someone snoops in with a camera or a microphone, you've now committed a tort above and beyond trespass. Okay? The second one, and I think this is close to what Ashley was talking about, it's called appropriation of image. This is effectively what happened in the Vanna White case, kind of, right? Where someone used someone else's image, name, or likeness, as it's defined, for some other commercial purpose. right? So I can't go take, a picture of Britney Spears and put it on, like, my casebook cover, right? I would need to actually have her permission, okay? The third one is actually one of the bigger ones called public disclosure, private fact, okay? What does that mean? Well, this is interesting. So I mentioned a moment ago, if you have some personal pictures, whatever, and then you share them willingly with another person, right? I have these pictures, me in a bathing suit, whatever, right? I send them to someone else, just one person. Did I just make them public? The answer is actually not that clear, right? Say I put it like on my blog so that the entire world could see, right? That would probably be making the image public. But if I send it to one person, perhaps somebody that I trust, maybe a family member or a friend, it's not clear that I've made that public. But then that person then blasts it on the National Enquirer, goes sends it to TMZ, right? I'm total TMZ fodder. That would actually be an actionable tort for public disclosure of private fact. Merely sharing information to people in your circles doesn't make it public, right? And this is a part of the Vanna White case. We want people to share information. It'll be a very dangerous world if we couldn't trust even our friends to share information. Although often that's not very good when you have pictures, okay? The fourth one, which I also think Ashley alluded to, is called the false light, right? So say, like, I take a picture of, like, Ashley, and I put, like, a caption on my blog, a terrible law student, right? Flunking out of law school. And I just say all these horrible things, right? That would also be a slander and a libel or whatever, right? But also, I'd be placing her in a false light. I'd be saying false information about her. So these are the four main privacy torts that are in the restatement. And different states have adopted them at various levels, although more or less these torts exist everywhere. What? Cart of cigarettes, an Olive Garden gift card? I don't even get that. Okay. I don't get it. Anyway, I think good try. Good try. Anyway, okay. So they have these privacy torts, but even though they're torts, they're mostly grounded in property, right? And true constitution that requires you actually being in a private place, right? Appropriation of image. Your image is your property right, right? The public disclosure, not so much. False light, a bit less. But a lot of them have very strong property vibes. Okay? All right, any question for you to do the Vanna White case? Okay, let's do the Vanna White case. Everyone knows who Vanna White is? Everyone, has anyone never seen Wheel of Fortune? Be honest. Everyone's seen it, okay? Good. I mean, I actually checked this. This show has been on the air since 1982. Vanna White started the show when she was 25 years old. She's now 57. This was her in an earlier incarnation, maybe 30 years ago or so. Okay? So everyone knows the general gist of Wheel of Fortune. Okay? There's a wheel of fortune. Thank you. Yes. There's a Wheel of Fortune with dollar values on it. You spin the wheel. If you get whatever, then you have to go to a letter board. You guess letters. It's like kind of like Scrabble, trying to figure it out. You have to try and figure out the words. It's a game show, okay? So here we have the ad, okay? Here we have the ad. So Samsung, everyone knows Samsung. They make electronics, right? In the late 1980s, early 1990s, they came up with an ad campaign, and they were trying to show that their products, right? That their products would last for a very long time. Okay? And then to show this, they wanted to see things that exist today that might not be existing in the future, but Samsung will still be here. So, for example, here's one of the ads: piece of raw steak, right? Raw steak. And then it says in the year 2010 AD, it's revealed to be health food, right? So something which in the present we know to be totally false, future we find out it's true. Okay? But in the year 2010, people still be using a Samsung microwave to cook it. So everyone get the gist. It's kind of, it's not very funny. But it's like saying, even in 30 years, things will be totally different, but you'll still be using a Samsung product, right? Okay. So then we come to Vanna White. This one will make a lot of Marcette Crone. It's because it's quite ironic. It says, in the year 2012, I think they anticipate the Mayans, so they didn't go past 2012. But in the year 2012, left. So in the year 2012, they say the caption says longest running game show. Okay, and for any of you who have seen Wheel of Fortune, it's pretty obvious what this is a picture of, right? This is the Wheel of Fortune game board. By the way, Vanna doesn't even turn the letters anymore. Now she touches them. It's all, so we got that wrong too. So the Wheel of Fortune game board, right? But instead of Vanna White, you have this robot, kind of like a C-3PO style robot with with jewelry and the gown and the blonde wig, right? So they're trying to make you think that at some point Vanna White will be replaced by a robot. Okay, and so the bottom half of the ad goes like this. Right, yeah. The VCR, you'll tape it on in 2012 AD. So they're saying, even though Vanna White will be replaced by a robot, you'll still be using a Samsung VCR to record it. Okay, they could not have been more wrong if they had tried, because VCRs don't even exist anymore. I looked. You can't even buy one on Amazon. It's like a VCR DVD combo or something stupid, right? Okay, but their point they're trying to make is this shtick. It's like, listen, this VCR will last you 30 years. Right. Okay. Whatever. Okay. So jokes on them. In the year 2012, which was not that long ago, VCRs are long gone. Vanna White's still kicking butt, and you know everything else is working the same. All right. But the problem is, when Samsung made this advertisement, they did not seek Vanna White's permission. Okay, they didn't ask her for her permission. They didn't even pay her, give her a cut of the royalties. Okay. By the way, I actually looked this up. There's only actually one wheel. I know they have shows across the country. They actually bring the wheel with them whenever they travel, and they disassemble it. And I looked this up too. There was one episode where Pat Sajak had laryngitis, and Vanna White hosted, and he flipped letters. Progress, right? Yes. He did not wear a gown, though. I don't think so. I think they kept their own attire. Okay. So Vanna White, when she found out about this ad, she was angry. She filed a lawsuit against Samsung and the advertising design company. Okay, and I'm not so much concerned about the statutory causes of action, right? She brought something under California law and under the Lanham Act. So I'm not too concerned about those because you won't come to it again. But I'm more interested in what the court did as a matter of common law. And when I say common law, I mean the court started to develop property rights the same way that the INS VAP case last week, they developed a property right in the articles. Okay? All right. I still don't get that Olive Garden joke, but I'll move on. All right. Let's see. All right, Eddie, start here. Okay. So what did Vanna White claim? What was her argument about why she should win this case? Very good. Okay. So her image, but specifically, was it her image or was it something else? Because I mean, ready? This is Vanna White. Okay, that's what she looks like, and this is the commercial. So Eddie, what exactly about it was being exploited? So let's be precise.
Yes, regarding her actual person, her function.
Mm-hmm. Good. Okay, is that Catherine?
Yes, sir.
Catherine, what exactly was it that this commercial, Eddie's word, exploited? What was exploited here?
The right of publicity.
Okay, tell me, what's this right of publicity?
That's a tougher question.
Uh-huh.
It was being exploited, I guess, her right to disseminate her own image and like her proprietary rights. I'm
Yeah,
doing it correctly. It doesn't look like.
Okay, so actually, you see the difficulty here, right? What exactly is Vanna White complaining about, right? It's very easy to say Vanna White had her image appropriated, right? But let's drill down, right? Elise, what exactly on this picture relates to Vanna White? What exactly is the connection between this picture and Vanna White?
What she's doing.
Okay, what's she doing?
She's doing her job.
What's her job?
She's the host of the.
So she's flipping the letters, right? Okay. But does this right of publicity cover what someone looks like, what someone does. What is this right publicity?
Usually it's about the name and the image.
Okay, the name and the image, right? Is that Christian?
Yes.
Christian, let's just focus on name and image for a second. Don't ignore the game board for a second, right? Just look at the little robot. What is the connection between this robot and Vanna White? Let's be really precise.
Dress, jewelry, wig, blonde hair.
Okay.
Like or like more.
Okay. So, how many women in America, and I'll ask Eric, how many women in America have blonde hair, wear pink dresses, and have jewelry? A lot. I'm guessing it's in the millions, right? I mean, I haven't done a survey, but I'm guessing there are a lot of people in America who have long blonde hair, wear wigs, or wear long blonde wig, whatever, right? Have jewelry, and wear like a pink gown, right?
Yes.
Yes, right. Yes, right. So Eric, how is this enough to make you think of Vanna White? How is this enough to connect with Vanna?
The dissent says it isn't or shouldn't be.
Let's not get to the dissent first. We'll do the dissent in a few minutes.
Well, by itself it isn't, because it doesn't use her name and her likeness, so it could be anyone.
Okay. Right. So is that Brian?
Yes.
So Brian, what's the kicker, right? What is it about this advertisement as a whole that connects to Vanna White?
I think it's the nexus between the show, like the setting of the Wheel of Fortune show, which is pretty iconic, with the blonde robot and all the.
Okay, good. Right. So it's not the blonde wig and the robots don't have real hair, right? It's not the blonde hair and the pink gown, the jewelry that's enough. It's the fact that this woman, or fembot, whatever, right, is standing next to the. Remember Austin Powers, the fembots? Right. So it's this blonde wig robot, but she's flipping, as you said, the iconic, right? This iconic game board. Everyone, or at least most people, know the Wheel of Fortune game board. You spin this around. Okay. So let me take a step back here, right? Everyone remember at the very end of Wheel of Fortune, what's the very last thing? Who produces Wheel of Fortune? So Merv Griffin. This is a Merv Griffin production, right? People don't watch till the end. This is a Merv Griffin production, right? Okay. Is that Allison? Why is Vanna White suing here? Shouldn't there be other parties perhaps involved in this case?
Because it's her likeness being praised.
Ah, okay. Now this might be a surprise to people in Texas, but in Hollywood, there are lots of people that go into developing an image, right? I'm sure she's a stylist, a wardrobe consultant, a producer to tell her how to stand, how to turn the letters. There was a game designer who actually designed the game, right? There was someone who actually flipped the, you didn't build that, Vanna, right? Someone actually built this game board, right? Right? Can we build it? Yes, we can, right? I'll build it. So, Allison, what stake does Vanna have in her own image?
Well, that's what she uses her image like to make. That's her how she makes her living is by being that.
Right. And this is Ashley?
Yeah.
Ashley, who created this image?
I mean, I guess the show, the producers, the whole. I mean, she became Vanna White because of that show.
Yes.
Doing her job.
Yes. Okay. So this is actually what's tricky, right? Literally, Vanna, you didn't build yourself, right? There are a lot of people who went into making this image of this, this elegant game show hostess, right? Vanna White didn't show up on day one and say, okay, I'm going to do this entire thing myself. She had produced it. Okay, Vanna, you stand here. Okay, then here's how you turn the letter. I promise you, there were meetings where we discussed how to position your hands. Like this is serious business, right? If anyone have any acting or Hollywood experience? It's really hard. I have done not acting, but even reading a script. Like I've done videos from a script. That's not easy. Trying to memorize a script and verbatim and delivering line for line and doing it naturally. There's a lot of work that goes into that. So effectively, before we get too far into this, it's not clear that Vanna White even owns her own image. Now that's messed up, right? That I think Ashley asked about that before, but that's a somewhat disturbing image, right? Maybe we can use Brittany again as an example. There are a lot of people that built that image, a lot of people that developed what went into that, right? Anyway. So here's the issue, right? So it's probably the case that Vanna White couldn't bring this lawsuit by herself, right? This should have been a Merv Griffin lawsuit as well. You know, they could have Merv Griffin come and everyone could say it to Beverly Hills Hilton or whatever, right? Let's go back and assume, just assume for the moment that Vanna White is the correct plaintiff. I don't think she is, right? But let's say that Vanna White's the correct plaintiff, okay? So Jacqueline?
Yeah.
So Jacqueline, what's Vanna White's best argument about why she wins this case? What's her best argument?
Well, I mean, they use her identity to kind of promote their advertising, so she can't, without her consent, so that was her selling point.
Mm-hmm.
She isn't getting any of their profit. She has no control over how they use her identity.
Okay. So and I think we had this a little bit before, but is your argument mostly that she's not going to get cut of the action?
Yeah.
Okay. All right. So Calvin, tell me, beyond financial damages, right? Vanna White suffered personally from this commercial. Let's go back to the commercial, right? Put aside financial damages for a second, right? Does she suffer personally in any way? Is there any personal injury to Vanna White as a human being because her image was used in this manner?
No.
How come? Tell me why.
That's not a derogatory ad in any way.
Sure it is. It's going to say she's going to be replaced by a robot. That's that's being mean to her. Or maybe she'll become a robot. I don't know. She'll become cyborg.
I didn't see where she was actually injured by.
Okay.
Personally injured.
All right. What do you think?
Seems to say someone that,
Yeah, go for it. Yeah.
that seems to trivialize her in some fashion.
Ooh, how's it trivializing her?
Even a robot can do what you do.
Well. She doesn't even flip the letters anymore. Is that Ravi in the back?
Yeah, I would say, well, consider Samsung a bad company. It's
Yeah.
basically assuming that she's endorsing them in some way.
Okay.
And they could look bad on her, but
Right. Okay. So even beyond financial, right? This is putting in her a light as if she's endorsing these Samsung VCRs, which she may or may not actually do. Okay. So, but let's try to move not anything financial. Right? Is there a personal injury to her, personal, that it hurts you somehow, makes you cry at night, that someone's putting your image like this? Yeah, go for it.
I don't think so. And I think I kind of like what the distinction between privacy and property is, that privacy is you're protected an injury of invasive privacy versus like a publicity, which is like the property right to your identity.
Okay, let me ask this a little bit differently, okay? Celebrities are in an odd spot, right? Their job is to get as much attention as possible, but only when they're getting paid for it, right? They want as much attention as possible, but they don't want someone to exploit their image without their knowledge, right? But us, people in this room, we might not be such star searchers, right? We might not want this, right? Why do a lot of people not want to be in public? Jonathan, why do a lot of people just not want to have their picture blast in the news and just want to kind of stay in their own realm and not have anything to do with this? You gotta talk louder.
They don't want to be bothered.
Why? Why? Why do people not want to? Why do people want to be let alone? Would you want to be broadcasted all over the place? Do you have any preference?
no.
No. What do you think? Oh, your name's not on this. So. What's your name?
Selena.
Selena. What do you think?
I mean, the negative thing about having my image out there, if I don't want it out there, is I don't know what it's going to be. Like, I remember there was a story a few years back when a girl, she had done some modeling pictures on her own, just regular headshots.
Right.
And then all of a sudden she's driving by, she sees her face at a billboard for an abortion. And she never expected that. So, but I don't have any control over that.
Control. Okay, that's the word. Thank you. I didn't mean to cut you off, but you get the exact right. Control, right? This is the exact issue in the cell case we'll do next, right? We want to have control over our own stuff. We want to have control over our own property, over our house, over our land. We want to have control over our own cells, my organs, right? And we want to have control over our image. Putting aside money, We don't want people using us in ways that we don't consent to. Right? This has nothing to do with the Vanna White case itself, but generally we want to control how we're used, because otherwise there's an injury to ourselves. We don't like to be exploited. People don't like to have their things used without them. Right? Everyone got that? So what the court basically says here, and this is actually the majority opinion, they say, you know, there's little doubt about who this is meant to depict, right? There's a long gown, a blonde wig, jewelry, you know, the letters on the game board. This is obviously a Wheel of Fortune set. The court says, Vanna White dresses like this, turns letters, and does this in the Wheel of Fortune show. She's the only one. In other words, there's only one person they could be referring to with this ad, and that's Vanna White. Okay? Based on this fact, the court, the majority, finds a violation of something. They're not quite clear what it is, right? They talk about, you know, this common law right of publicity, which is not governed by the statute. The statute has these elements, whatever. So at this point, the court's making it up. You will soon come to know and love the Ninth Circuit Court of Appeals. The Ninth Circuit Court of Appeals, which Judge Kaczynski calls the Hollywood Circuit, is based in California. And they're a little bit loony. Ditto for the California Supreme Court. I'll give you a hint for all of your classes. Whenever there's a case from California, they're about to get rid of a common law rule. It's really 90% true. Any case, in this class particularly, any case you have from California, especially like after 1950 or so, they're going to get rid of a common law rule and do some sort of fairness stuff, okay? Okay, yes, sir.
Is that why they brought the likeness lawsuit against the NCAA in California?
Perhaps. Ooh, yes, let's talk about that likeness lawsuit. I was going to talk about that later. Tell us about what's this lawsuit against NCAA?
The players want to get paid because they're using them for video games.
What players?
Television. Ed
O'Banion.
And well, first they tried to do a class action, I think, but they wouldn't certify the class.
Okay. So here's the issue, and this is actually very similar to the Vanna White case, right? So everyone knows that there's college football, and they make video games based on college football, right? It's called NCAA 2013, 14, whatever, right? They actually stopped making it. When you play these games, they're very realistic, and they actually use the faces of the actual players. They actually copy their heights, their weights, you know, their builds, their faces, everything about them. So if, you know, your favorite team is whatever, you can pick your team and say, oh, I want to play with that player. Okay? Ditto for basketball. They have the NCAA basketball games, and they get their faces, whatever. Okay. As I'm sure, whenever you college athletes, D1? Anyone? Okay. Did you guys get paid for your athletics? No. What'd you get?
Yeah, scholarship.
Okay, good. So you get scholarships. It's currently against the rules in the NCAA to pay student athletes. And I put that term in quotes lightly, with no offense to my friend over there, right? You can't pay student athletes. Okay. So then who gets all the money from these video game royalties? We're using the person's name and face and likeness in these games. Okay, for years, the NCAA said, okay, no, they're getting their scholarships. They're getting confirmed. And these video games make millions and millions every year. So, yeah, I mean, it's a huge industry. So a former NBA player, Ed O'Banion, brought a lawsuit where he said, hey, listen, you use my face in this game without my permission. Give me a cut of it. And this lawsuit's actually winding its way through the courts now, and the judge basically ruled that these athletes can be compensated. In fact, they actually stopped making the NCAA game because they're not going to be able to anymore. The next shoe to drop is when the sports conferences start actually paying players, which I think will actually happen in the not-too-distant future. And that will really shake things up, but I think for the better. Yes, sir?
So they actually won that litigation, correct?
It's still ongoing, but pretty much.
Okay, so they just figured that screw it, we can make more money off of that in any ways. We don't want to get into future litigation issues.
Well, Electronic Arts, EA, they make the games. They basically said, we are not going to continue making this game because it exposes us to too much liability, right? And for them to have to go and find and track down every single player that was ever in the league individually won't work. What will probably have to happen in the future is that the teams will basically pay the players and actually sell the licensing rights, and the players get a cut. That'll probably how it'll be done.
doesn't Madden just pay the union or whatever?
Well, yeah, the NFL's agreed to have their likenesses used. If you remember the old NBA Jam game, Michael Jordan was never in it. Remember? Deliberately, because he didn't give up his likeness to be used in the video game. So he always had to put Scottie Pippen and Horace Grant. Right, so yeah. Yeah. Yes. Anyway. Fire today. So, see if you get that one, yeah. So anyway. So yeah, so we have decisions, but so this was the majority opinion, right? The majority opinion. So I'm going to give you a little lesson in appellate procedure. So in the courts of appeals, you have a case with 3 judges. Okay, in the federal courts of appeals, you have a case with 3 judges. This decision actually is split. They said that there was one judge who kind of dissented in part. Okay, what happens after an appellate decision is final? Well, there are 2 things that happen. One, they can appeal to the Supreme Court, right? So the first option is they file what's called a petition for certiorari, which you should know that word by now, but if you don't, now you do, with the Supreme Court, right? That's one option. The other option is something called a petition for rehearing en banc, or the entire appellate court. What does this mean? If you don't like the decision you got from the 3 judges, you can ask the entire court to hear it again. So, for example, the 5th Circuit is based in New Orleans, right? This is our local appellate court. If you get a decision you don't like, you can then ask the entire appellate court to look it over again. These are very rare. Most courts only grant a couple of these a year. Generally, 1 to 3 judge panel decides it. That's the end of the ballgame. Okay, but here's an interesting little wrinkle. Say that a majority of the judges don't want to hear the case again, right? One judge can write, and here's what's called a dissent from denial of rehearing en banc. So get this. A judge can actually dissent from the fact that his court didn't rehear the case. Everyone get that? Even though the case is dead and the court won't rehear it a second time, a single judge can write a dissent from the denial of rehearing en banc. And if you want to be really cool, it's called a dissental. It'll be really cool. This word will be in the dictionary in a couple of years. I'll explain why in a second. A dissental is called a dissent from denial of rehearing en banc. Okay? And the creator of this word, and I'm sad Ilya's not here yet, because he married a former clerk of his, is this judge named Alex Kaczynski. He is the judge who authored the dissental. And Judge Kaczynski, who's a dear friend, will be proud because he is championing the word dissental to go into the dictionary. I actually had a student who used this word in an exam last year. And I sent it to Kaczynski, and then Kaczynski sent it to Brian Gardner, who publishes Black's Law Dictionary, to try and get it in. It won't be in this edition, it'll probably be in the next one. Okay? I have a tiny claim to notoriety. I got a word in the dictionary. So, everyone ever seen Justice Ginsburg? She wears this kind of frilly lace thing around her neck. Okay, so the proper name for that is a jabot. But I've been calling it for about 4 or 5 years now a neck doily. Check your 10th edition of Black's. It hasn't come out yet, but it'll be in there. Neck doily. Yeah. No, but I'm proud. You kidding me? I do for free. I pay him to put a word in. No, Brian Gardner, the publisher, actually tweeted the page from the new dictionary print saying neck doily. He tweeted me. He was like, yes, I got my. That's all I need. I'm happy. I'm happy. Anyway, so Alex Kaczynski is a judge in the 9th Circuit. And I'm sorry Ilya's not here because you know this judge well. So he wrote a dissental. He's saying, listen, you guys messed up, and we should rehear this case again. But they're not a vote, so I'm just write something because I want to. Okay, that's what a dissental is. It's kind of like just saying, right, he's giving his opinion. But in this case, he was trying to do something else. He was trying to alert the Supreme Court to take this case and reverse it. Right? If you notice that he keeps saying this is an error that should be corrected, ahem, ahem, well, who's going to correct it but the Supreme Court? So this is like Alex Kaczynski trying to bat signals to the Supreme Court saying, you guys fix this mess. Yes?
The U.S. Supreme Court.
Of course, United States Supreme Court. Yeah. So everyone knows there's the U.S. Supreme Court, and underneath it there are 13 courts of appeals, right? 1st, 2nd, 3rd, 4th, 5th, 6th, 7th, 8th, 9th, 10th, 11th, D.C., and the Federal Circuit. And each of these are federal courts of appeals underneath the Supreme Court. Okay. We are in the 5th Circuit, which is Texas, Mississippi, and Louisiana, right? This is our home turf. Anyway, so Kaczynski wrote his dissental, if you will, and he'll be very proud I used that word because he's been pushing it for a couple of years now. Let's see, Lou, what did Judge Kaczynski write in his opinion?
In Vanna White case?
Yeah, the Vanna White case.
He was basically like.
He's very dramatic.
Yeah. But yeah, he just cut it out. But one of my favorite parts that he brought up that it's like it's not anything about her that makes it clear that it's her identity. It's it's the game. So like her identity is her job.
Yes. Yes. And that's the point we made before, right? Where she doesn't own her own image. This is actually a Wheel of Fortune Merv Griffin production. It says so in every episode. But Lou, what did Kaczynski actually hold? What was his finding? How would he have resolved this case?
I can find that as soon as someone told me.
I don't. Alex, you got it? Is that? Oh, who are you?
I'm Reed.
Okay, you're not on the chart either. Okay. You're Reeb. Okay, I'll. Okay, Reeb, tell me what did the court hold?
Oh, the court.
I mean, no. What did Judge Kaczynski hold in his dissental? It starts on page. Yeah. It's hard to see the break of where one judge starts. Ah, welcome. So we have a guest today, Ilya Shapiro. Ilya is a fellow at the Cato Institute and a good friend of mine. And are you wearing a bolo?
I am.
Are you wearing your boots?
I am wearing my boots.
Okay. Ilya,
It's a Supreme Court roundup, you see.
Yeehaw. Yeehaw. So Ilya, you just missed by about 30 seconds my discussion of this man. Ilya is actually married to a clerk of this man. His name is Judge Kaczynski, and I told him.
Performed my naturalization ceremony.
Yes, Ilya became a citizen this summer. Welcome. Now you have to pay taxes, and no, you already paid this.
Now I can tell the government what I really think.
Ah. But I also told him about what a dissental is. Ah, the dissental. And I did not make the word up. So if you want to have a seat, you're welcome to. Anyway, we're about to discuss Judge Kaczynski's dissental in the opinion. So, Reeb, what did Judge Kaczynski say? What was his argument? Do you guys have this? Maria.
I mean, the evisceration? You're talking about that?
His opinion begins, something very dangerous is going on here.
Oh, yeah.
Right? Everyone see this opinion. Maria.
So he's talking about.
Go for it.
Talking
Yeah.
about how everything was private property, and how you can't really be original anymore because as things. If I remember correctly. So like if there's no such thing as originality anymore.
Yes.
Creative people who build upon other people's work to make their own work. So this is kind of the same. They're trying. So it's kind of sad that they're trying to make this wouldn't be funny if it wasn't Vanna White in such a situation.
Mm-hmm.
The whole point of the ad was to be funny.
Okay, good. So here's the thing about privacy law that you may not realize. There was a great article by Eugene Volk about this. My right to privacy means I tell you not to speak. What? Whenever I assert a privacy right, I'm shutting you up. I'm saying you cannot say that. You cannot make this advertisement, right? I am stifling your creativity. There's this inherent tension between privacy and free expression that I encourage you to pursue if you take common law or privacy law. Anytime I say, oh no, that's private matter, I'm telling a reporter, you can't print that story. You can't publish this picture. You are censoring and stifling my speech to the arm of the government. So you see the problem here, this is what Judge Kaczynski alludes to, right? Protecting the property, protecting Vanna White's image in this case stifles creativity. It's telling Samsung that you can't make this commercial. And it's not even using Vanna White's image, it's using something that might remind you of her as a robot. And Kaczynski says this is dangerous, right? he says that overprotecting property is as harmful as underprotecting it, right? Maria, what's the harm here? What happens if we give too much protection to Vanna White's image?
That it's just going to create like a new standard which will probably open floodgates to people suing when they're trying to make fun of something or.
Good. And what's the cost of all these lawsuits? What's going to end up happening? If people are under threat of lawsuits, what do they usually do? No. Flora, if someone's threatening to sue you for making an advertisement, what are you going to do? You not do it. Right. You stop creating. The cost of IP is that it threatens innovation. Right? If I know I'm going to get, if there's a judgment here, right? What if one day I make a robot Alex Trebek, right? The guy with a mustache and at least Canadian. You know, oh, you're not Canadian. Did you renounce your citizenship yet? Actually, on the day he got sworn in, I handed him a form to renounce his Canadian citizenship, and I offered to walk it over to the embassy, but he declined. Actually. Wouldn't what? I didn't hear.
Barring something or stopping something will also force creativity, but they're having to use an alternative or something else, or make it up on their own, or instead of using an image of something that's already there.
Well, okay, so I think Judge Kaczynski made the point well. There's nothing new under the sun, right? Everything is based on something else and based on something else. So if you say, oh, you can't do this, and you can't do that, and you can't do that, after all, there's not much stuff you can do. Okay? This is especially dangerous in my mind when we're dealing with humor, right? Everyone watched Saturday Night Live? Anyone ever see Celebrity Jeopardy with, you know, Will Ferrell and, you know, Daryl Hammond and Sean Connery, right? Okay, Matthew, how come you know Alex Trebek, the gentle Canadian, didn't sue Will Ferrell for, you know, appropriating his image?
Is it parody? Like
parody. What's parody?
Making fun. So not making fun.
Okay, but I mean, this is really clear. I mean, Trebek, right? He was copying Alex Trebek very clearly. Why is that allowed?
Well, it was a joke.
So what? Why do we make exceptions to intellectual property laws for jokes? Ah, no one thought about that.
Maybe just to allow creativity
or... Why do we want to promote creativity as a society? Why is this something we want to develop?
That's how we invent new things and discover new things.
And what else? And what else? What else about SNL? Or maybe not now, but years earlier. Why do we want parody? What does that do for society? Think about it.
Well, I mean, I know it can create awareness of that person that they're parodying to potential untouched audiences.
What's the value of having parody?
It's like a compliment.
I could go back to that right of publicity. It's kind of getting someone else's name out there.
Why do we want to promote parody? Yeah.
To criticize like government officials.
Yes, it's funny. It's funny. We want, right? We want to be able to have an open discussion as a free society. We value free exchange of ideas. The way to criticize someone is often making fun of them, right? We make fun of people as a release valve to actually have an open society. This is good. When you start having a court saying, no, you can't make fun of me, and oh, you can't parodize that, make a parody of that, you're in trouble. Yes, sir.
Isn't there a line, though, as far as parodies go, or maybe it's just simply imitation where they have to seek the approval, like your Weird Al Yankovic's and stuff like that. He seeks approval prior to parodying a song.
Okay, I'll
This is the example that came to mind was the Harry Carey skit by Will Ferrell, but since it's parody, it's kind of aside from the point. How does it like? What if the person that is being imitated is dead?
Okay, well let's talk about this, right? So this is getting a little bit more into statutory IP policy, but generally it's something called parody exception, right? If you make a parody of something, you can actually copy it. Also something called fair use, right? If you use a small clip of something, you're generally allowed to. And the reason why is that it promotes creation of new things. Now, you mentioned Weird Al, and if you ever want to talk about rap music and sampling, right? This is where you take a sample of someone else's music and remix and do something else to it. Generally speaking, though, Weird Al gets permission. He actually does ask people in advance. Sometimes they say no and they sue him, whatever. But if you take someone's copyrighted music, you actually need to pay royalties on it. Yes, sir.
Well, like South Park, they put a big disclaimer.
but it's obviously.
Well, South Park is parody, but they have been threatened with lawsuits. So there was actually an episode a number of years ago where they parodied the Scientologist and Tom Cruise, right? And it was, Tom Cruise was trapped in the closet. Anyway, if you look at the closing credits in the episode, everyone's name was John Smith. No one was willing to take responsibility for it, right? All right. So, and I'll call him Ilya. Ilya, what's the problem when SBA, right? What's the problem
It's been
when
14 years since my 1L property class.
Oh, that's right. What's the problem when we start punishing people and saying that they're speaking falsities when they're actually perhaps not? What's the danger of the government trying to assess what is true and false? You talk about the SBA case.
Well, it's the government deciding who and how, who can criticize it and how.
Isn't that a dangerous thing?
Yeah.
Yeah, very dangerous. It gets dangerous when courts and the government start deciding who can speak and who can't.
You have a Ministry of Truth.
You have, yes, we were in 1984. There's a Ministry of Truth, and we actually have that in Ohio right now. There's an Ohio board that decides whether politicians are speaking truth or not. Okay? So, like Ecclesiastes, yeah, nothing new under the sun. So Kaczynski says, listen, right? We want to have people create, develop, innovate ideas. We should be construing these property rights more narrowly, not quite so broadly. Right? We want to encourage creativity. Okay? The mere fact, and this is actually what Kaczynski gets to, it's an interesting point, we're not actually protecting Vanna White's image. We're protecting a thought process that reminds us of her, right? A thought process. Think about that. Vanna White now owns a control over our minds. I'm not saying it's like in a reptilian method, right? She now has an associated property right. If anything people do make us think of her, right? If I make something that makes you think of Vanna White, she can now sue me because of what goes on in the human mind. That's quite bold, which is why I think Kaczynski was more outraged than usual. Okay? Kaczynski says this is an appropriation of her identity, right? At the very end, he goes on to talk about the First Amendment, which we don't do in this class, but you should do in common law, right? This is an unparalleled restriction on speech. That now people are actually at risk of a court order if they use something to think of Vanna White or any other celebrity. Okay? And Kaczynski says that this is the Court of Appeals of the Hollywood Circuit, which we have a right to mock. All right. So as an afternote, the Supreme Court did deny certiorari, and Vanna White got $400,000 in damages. Okay?
For that?
Yeah. For that.
Wow.
I wish you should have the one, Ilya. So basically, the shtick was, they said, longest-ranked TV show in 2012, said a robotic Vanna White, and the bottom was, the V-story you'll tape it on in 2012, which is pretty ironic because it's the exact opposite, because Vanna White's still rocking the board. Okay? Anything else in the Vanna White case before we move on to the other case? Anything else? Okay. So the next case we're doing is Moore versus Board of Regents of California. And before I start, did anyone ever read this book, The Secret Life of Henrietta Lacks?
I think it was incredible.
Tell us about it, please.
It's about the woman who is like from her cancer cells were created Gila cells, which have been used to study a whole bunch of cancer and just a lot of biomedical bioscience.
Haley, did you read this one? No. He reads like a book a week, so I'm actually disappointed at that. So, this story, and I encourage you, it's a good read. It's an actual thing. I got a testimony, not just me. It's a good book. The Immortal Life of Henrietta Lacks. So here was a deal. Henrietta was this poor black woman in Baltimore during the 1950s and 60s. And she had some form of cancer. And at the Johns Hopkins University in Baltimore, they gave her some treatment, okay? What they didn't tell her was that they kept some of her cells after they did this treatment. And Henrietta's cells are unique, because usually if you take some of the cells out of my body, they'll die fairly quickly. But something about Henrietta's cells were different. They reproduced indefinitely, infinitely. In fact, one of the lab techs had put her cells under a petri dish, and then he came back the next day and they were all like over the place, right? This had never happened before. So in order to build what's called a cell line or a cell culture they can do research on, they basically just put Henrietta's cells in a dish and let them grow and grow and grow. These became extremely commercially successful, right? Extremely commercially successful, making millions and billions and billions of dollars. The doctor never told Henrietta about it. She never told her family about it. In fact, Henrietta died, a poor woman, not knowing a damn thing about it. Okay, it's actually a really sad story that only now is coming into clear. So this woman, Rebecca Skloot, wrote this book about it, where she tracked down Henrietta's family and tracked down the doctors, and they basically found that they were using her cells without permission. Okay, there's something of a happy ending. I don't know if you can call it happy. In 2013, the National Institute of Health reached an agreement that said, if you want to use Henrietta's cells, you need to get the permission of her family. I mean, but her family can only consent. They don't get a penny out of it. And billions of dollars have already been made off of this cell line. And in large part, that judgment was based on this California case we're going to do today, where the court held that the only thing you can have is consent. You don't get any cut of the cell line. Okay? So if you can, read that book. It's a very emotional book too. It's very sad. This poor woman, she had no idea what was going on. They really took her for a ride. But your book gives us the Moore case, where he actually found out what was up. Right? He found out what was going on. Okay? So let me give you some of the background of the story that's not in the book, but I think you'll find interesting. So we're dealing with Mr. Moore, right? He was working on an Alaskan pipeline, and he got ill. His gums started bleeding, his belly swelled, he had bruises all over his body. And the guy was 31. He was a young guy, and he didn't know what was going on. He thought he was dying. So he went to this hospital in California, in Los Angeles, and when he got there, he signed some random form that the hospital could dispose of any tissues or whatever, right? Okay, so they open him up, and they check his spleen. Okay? Usually his spleen weighs about 1 pound. His spleen weighed 22 pounds. So I mean, the guy was engorged. He was huge. All right. So they removed his spleen, okay, and then the guy went back to work. Moved to Seattle. Okay. For the next 6 years, he flew back to Los Angeles to, get checkups, or at least so he thought. And every time I went, they kept taking more and more cells. And then after a while, it started getting a little bit weird, right? They were putting him up at the Beverly Wilshire Hotel, which is a very expensive hotel. They were like flying in business class to come to LA. And like he didn't really know what was going on. He was like, oh yeah, sure, whatever, they're treating me nice. And they weren't charging him a penny. And they kept treating him nicer and nicer. Okay? And they were taking, bone marrow, blood samples, like, why are they taking all this stuff? Okay? So then he went again, and the doctor gave him some sort of new consent form. It says, I do grant to the University of California all rights in any cell line that I may have, right? And then he checked the yes box, okay? And then this went on for a couple more years, right? And then, he's thinking, they're giving me free treatment, I don't really care. But then something tipped him off, right? And Moore asked the doctor, does this have any commercial value? Doctor says, no. Okay, by this point, they're already patenting the cell line, and it generated $3.5 billion. Like, this is ridiculous amounts of money. All right? Then it comes to the point where he checks the no box on the consent form, and he goes back to his home in Seattle. And the doctor calls, you checked the wrong box. And he's like, oh, gee, doc, I'm sorry, right? And the doctor's like, come back here. And he's like, no, I'm not going to do that. And then he mails the form to the doctor, as a patient, and he's like, I'm not going to sign this. And then the doctor sends a letter saying, stop being a pain, sign the form, right? At which point, what do you think Mr. Moore did? He hired a lawyer, right? What good things happens. And they found that for 7 years, they had been developing his cell line with all of his particles, which was pretty crazy. Okay? And they actually, Lou mentioned the name of the cell line for Henrietta was Gila, which was actually, in a weird way, the first 2 letters of her name. So it's like H-E-L-A. Guess what they call the Moore line? Mo. Talk about dehumanizing, right? They just took the first 2 letters of his name, Mo, right? Mo's Tavern. So So they took his cells, okay? All right, so then it goes to court, right? So it's, Nick, what did the trial court do here?
Trial court sustained the defendant's demurs.
What does that mean?
So more loss.
Okay, so more loss. Why did he lose?
Because he didn't have a right to his cells.
Okay, good. So we start, right? We start with the premise that the California legislature has not passed any statutes governing property rights and cell lines. Okay? We're back in Pearson v. Postland, right? We are back in the land where there's no statute governing it, and the courts have to, maybe they don't have to in this case, they have to fashion some kind of rule to decide the case. Marcel, what did the appellate court do here?
First they said that it wasn't unique because.
What do you mean?
Because all mammals have.
No, the appellate, not the Supreme Court, the middle court, the intermediary court, the California Court of Appeals.
I don't remember what they said.
Ilya, no. I won't come for that. Mario, what did the Court of Appeals say? Are you? No, you're not.
I'm sorry, I'm supposed to be sitting on the right.
Yeah. What's your name?
Juan.
Juan. Okay. What did the Court of Appeals say?
They actually reversed the decision made by the trial court.
Okay. Good.
On the grounds that these family didn't have a transaction for. I mean, the lawsuit that he presented was for conversion. There was some other legal claims.
Okay. Good. Tell me, what's conversion? You do this in torts, right?
Yeah. Based on the definition, is basically taking someone else's property by stealing someone else's.
Not quite. Is that Mario? What's conversion?
Whatever you use in someone else's property.
Okay, good, right. So if like I, take his laptop and I smash it, right? I just convert his property to like junk, right? But that was a tort of conversion. Okay. So here, Moore is actually making a fairly creative argument. He's saying, since there's no statute, let me try and push this into one of our common law torts, right? Let me say that they were misappropriating or they were improperly using my cells without my permission, right? John?
Yeah.
Putting organs aside, whose property was being used?
Well,
whose cells were they? Were they? Well, when were they Moore's property?
when they were still a part of him.
Okay. What happens after the cells are removed from his body? Whose property are those? Okay, that's the tricky issue here, right? I have a hand, right? I have a head, right? This is all my property. If I drop something on the floor and I leave it there, or I give it away, it ain't mine anymore. The conversion tort only works with your own property. So the question is, do you retain a property right in something after it leaves your body?
Does it matter that he was essentially coerced?
We'll get to the consent issue later. That's actually a much easier issue, right? Right? The issue here is, putting aside the coercion, can you retain an interest in your bodily cells after it leaves your body? Tamara, what do you think? I mean, what does the court say here? The appellate court at least, can you retain a property right in your body after it leaves you? What's the appellate court say?
I would say yes.
That's right. Why? Harrison. Well, think about it. Logically speaking, why would you retain a property right in your body after your cells are gone? Think about it.
Because it was used to make profit.
I'm sorry, what?
Because the cells are used to make profit.
Does it need to resolve based on profit?
Be a profit. I'm saying it was used. The cells that were once in the body were actually used.
Jesse, what do you think?
Well, if you knew cells or his body parts that were being donated, he might refuse to donate as well. This could open up a lot of cases where patients might have things extracted from them that they would otherwise not consent to, or their body parts might be used in ways that.
Let's drill down. You keep talking about financial, which is fine, right? I want to talk about why does a person keep a property right in his cells, putting aside money. Is that Aaron? You're not on the sheet out there. Okay, Andrew, tell me. Why does a person keep a property right in his cells?
To make sure that he can continue to like reap the benefits from.
Put this in terms. We've been in this class now, what, 2 weeks now. Tell me why. What have we studied this term that will make you think that you have the right to keep a property right in yourself?
Because you have the original ownership.
Ah, good. Tell me more. You're on the right track.
I mean, it's. I mean, that's where I guess that's where I finish off at. I mean, it's originally yours. It should be yours, even though it's outside of your body. It's still your blood.
All right, Aaron. I think Andrew's close. Give me a little bit more.
Kind of relates to publicity.
The what?
The publicity with identity, or says plaintiff cells are named or part of this person.
Okay.
And for legal protection of individuals.
All right. Ashley? That's a good answer. Tell me more.
So you have the right to exclude people from taking cells from your body or giving consent, but he signed a consent form.
Okay.
And I guess it has a lot to do with informed consent as well.
Okay. I think you're all in the right ballpark. Do you remember we studied John Locke a little bit? Ilya? What does John Locke say about property in your own body?
You have it, and then you mix it, your labors with something else.
Good. Right. To Locke, what's the starting point of all property? You have a property right in your own body, and then you mix your labor with other things in the world to acquire property right. Right? I have my hands, I have my feet. I'm going to chase that fox, and I'm going to get it, and I'm going to make that fox mine. Right? I have these hands, I'm going to paint something. I'll make that mine because I'm mixing my labor with it. But the first step, according to Locke, before you get to labor, is that you own yourself. The starting point of our entire theory of property is that you own your body and yourself. And you see where I'm going with this about 30 seconds, but no one else can own you. The entire idea of personal autonomy, right, that this guy can't come up and push me, right, because I have a property right to myself. I own my body, and I'm not consenting to this. The entire idea of consent is you can't touch me unless I give you the consent to do so. Okay? Now, the opinion, the Court of Appeals decision, speaks directly to this. Because in this case, is that Alex? No one's in the right seat. You gotta, yeah. This is not good. You have to sit in your right seat, otherwise I don't know who you are. Jordan. Okay, so stay there. Jordan, that's your seat now. What's the problem in this case? Who's owning the cells of Mr. Moore?
They're saying that Mr. Moore does not own them.
So who owns it?
Whoever developed the cell.
The doctors, right? The doctors. So the specter haunting the Court of Appeals decision, right, is that someone else actually owns your body and your person. Right? That's Alex, right? Alex, what does that make you think of when someone else owns you? Slavery. You didn't think we'd talk about slavery today, did you? What's lingering in the Court of Appeals decision is actually fears of slavery. And I don't mean chattel slavery where a person's bound to the land, right? I'm saying someone else owns your most intimate, personal essence, your body, right? Someone else owns your body. And to the appeals decision, that's perhaps the scariest thing. They were trying to avoid that, right? You should have a right monetary right, as it were, to control how your body is being used. Otherwise, it's a form of slavery. Did anyone have a reaction to that argument when you read it? Did anyone not say, "What? What's this guy talking about?" Did anyone have a thought on that? Now, what do you think, Amanda? Did that hit you out of left field? Did that surprise? So, I mean, what did it make you? What was your reaction to that argument? Chad, what do you think?
Can't do anything with itself anyways. I mean, without the Regents developing it, it
Uh-huh.
was worthless. Yeah, I mean, spit on the ground, I don't know about that either.
By the way, you know if you spit on the ground, the cops can search that for DNA, right? Any garbage you deposit can be searched under the Fourth Amendment. So if you spit in the ground or you defecate or whatever, that can be searched. I'm serious. Cops can search garbage cans. Yeah.
I mean, just because I'm like a poor farmer that was endowed with like several thousands of acres of land and I don't have the means to like harvest the oil doesn't mean that I don't get the mineral rights for that oil.
Okay. So before we move on to compensation, let's just think a little bit more about the actual issue of ownership. So what the Court of Appeals says is it's wrong for the doctors to own these cells, right? Okay. At the Supreme Court, it flips. I'm specifically talking about the concurring opinion from Justice Arabian, right? Judson, if you want to take a second, what did Justice Arabian say in his concurring opinion? Hint for law school, the concurring opinion is usually more important because they usually give stuff that the majority doesn't. So those are usually the, if they're included, it's because they're important.
Part of the opinion to the legislature, like the legislature needs to come up with.
What was why was Arabian so hard against deciding this case?
I didn't get the entire question.
Why did Arabian? What was Arabian's moral difficulty with this case?
The selling one's right or one's body is profit.
What's okay? So now we're getting to the core, right? What's the danger of selling your body for profit?
Well, there's a lot of danger to it.
Tell me.
We have laws that keep you from selling like organs and things like that.
I know we have these laws, but why do you have these laws?
Because it's dangerous.
Oh, you just answered your question with your question. Why is it dangerous? Ah, so now we're getting to the deep issue. Why? Right, Justin, right? Why do we have laws preventing the sale of organs? Why do we have laws against prostitution? Right? Why do we have laws against selling your cells? All right, Justin, take a stab at it.
Because somebody in the past has actually.
So is our law just something but tradition? Ooh, Rafi, give me an answer.
I would say certain laws develop through morality versus society.
Morality? What do you mean morality? What place does morality have in the law?
I mean, it's the same situation why like cigarettes are taxed so high. It's a stigma tax. There's no other reason why.
All right, who else? What else?
It's our law is kind of a stigma on things that.
Yeah. Andrew.
I mean, I'm kind of like going, I guess, really more of a question. I'm kind of curious, like, since a lot of public opinion is kind of going the other way, as in I don't need like the government to protect me from myself, like banning 20-ounce sodas and banning marijuana and things like that.
What do you think?
Well, I remember that there was something in the, at least in the dissenting opinion about the thing I had a problem with was that poor people might be tempted to sell their organs.
Okay. We'll get to that in a second, but let's deal with the moral issue first, right? What is it about the body, the human body, that we find so sacrosanct, to use this word, dignity, right? Justice Kennedy's favorite word. What is this dignity of the person that makes us repelled with the idea of someone selling an organ or selling cells? Jason, I think your hand was up.
Just that we don't want it to become a commodity.
Why not? Why don't we want it to be a commodity? What's wrong with commoditizing things? Ooh.
But it does open a slippery slope of slavery and people taking advantage of others.
What was the moral basis then of slavery, among other things. That certain people don't even own their own bodies, right? Yeah, I mean, there were a lot of other things, but at heart, certain peoples did not actually own their own bodies, and they could be sold around like property, like chattel. So I think Jason has a point that when you start commoditizing people and their organs, that you eliminate this moral foundation that we are all individuals who own ourselves. Your hand, what's up?
I was going to say, is it perhaps to deter illegal?
That's a fraud argument. We'll get to that in a second. But let's stick with the morality of an issue, right? The reason why, historically, morality didn't want commoditizing human beings, and this is why we have bans on prostitution. This is why we have bans on suicide. Everyone know why suicide is illegal? We don't want people destroying life. Like, this is a judgment that society made over millennia, which I think still even pervades today. All right. We'll get to the financial in a minute. Anyone else have any other points on this one? Yes, sir.
Why do they not allow the selling of cells, but they'll allow you to sell platelets and plasma?
Ah, okay. All right. So here, though, is where it gets a little bit interesting. I'm sure people in the room have donated blood and plasma for money. Actually, plasma gets the money, right? As I've understood, right? We allow people to sell certain things, but not others. Robbie?
Is it because those are like renewable resources?
Okay, good. Okay, so there's actually an argument, right? I make new blood every day. I make new plasma every day. I only have 2 kidneys, right? If you take one of my kidneys, I will not grow one back. So, as a society, we've actually made an exception to this dignity principle for things like blood, plasma, and semen and eggs. And eggs are actually finite, but there's a lot of them, right?
Well, aren't they selling cells in this case?
Okay. Now, who's selling the cell? Selling the cell, right? Is the human being giving up the cell making the sale, or is it the doctors who are making the sale? Okay, so this is also interesting, right? The initial person who gives a cell can't profit from it. But the doctors who can then turn those cells into a cell line, they profit from it. Now you might say, well, they put all the effort and the labor into making that cell line, they transformed it to make it commercially viable. Mr. Moore's cells by themselves was not particularly valuable. Right? Yes?
When you sell plasma, though, I used to work at plasma. They give you like $20 and they turn around.
What's the markup?
A lot.
Okay, a lot. Okay. So, let me ask this question. Where was I up to? I forgot. Somewhere in the back. Oh, yeah, so I think it was up to Gary. Gary, what, a couple people have mentioned this, what's the potential, though, for fraud by allowing people to sell these cells and organs? What's the potential for fraud?
I mean, I guess you could say that they have certain characteristics that they don't.
Be more specific.
I mean,
I think I know what you're getting at, but you gotta be more specific.
like if you're selling cells and they're cancer-fighting cells when they're not, I mean, you could sell that to someone with cancer.
Actually, let me ask Marcel this question. Marcel, who are the kind of people that sell plasma? What are they generally looking for?
They're usually pharmaceuticals.
No, who try to buy it? I'm sorry. Try to sell their own plasma.
Usually people who don't have any money.
Yeah, poor people, right? Whoa, on cue. Poor law students, right? Dude, that was good. That was good, right? So, really, if you're well-to-do and you have a lot of money, you're not walking to the plasma station, right? Right. If you're well-to-do, you're not going to try and sell a kidney. Generally speaking, the people who want to do this will do it for the money. So this is a similar commoditization issue that we have with prostitution, right? Generally, people who are well-off, maybe actually do pre-accepted, are not going to go into prostitution, right? I mean, I'm sure it happens, but generally people go into it because they need the money, men and women alike. As a society, with morality, we also are somewhat paternalistic, and we want to protect people from making their own mistakes. And we can discuss that after class if you like. But we basically say, listen, you're poor. We don't trust you to make a decision that might hurt you, right? We don't trust you to sell your body into sex. We don't trust you to be a prostitute. We don't trust you to sell one of your kidneys for a significant amount of money because you might be exploited and someone might commit fraud. You ever think about that? That's why we have these laws, Marcel?
There were people that came in there where they had like family members who were affiliates.
That's true.
And so if they don't, if there's not a supply of plasma, they can't make the.
But those are a small percentage?
Yeah, of course, it was a small percentage of people that didn't need the money that came in for.
So let's talk for a minute about kidney markets. I might call an Ilya in a second. There's actually a blog post on Cato at Liberty, which I'm sure you read yesterday on this. No. Okay. So everyone knows kidney transplants are very difficult to get. Okay. So at the moment, I looked these numbers up yesterday. There are roughly 100,000 Americans on the waiting list for a kidney transplant. 100,000 Americans. Last year, there were about 5,000 transplants. Okay. Of these, only about 400 were from relatives. So less than 10% of these were from most of these were from relatives, right? Only 400 were from unrelated people. So very few people want to donate a kidney to someone they don't know. Okay? Every year, about 3,400 people die waiting for kidneys. So basically, 3,000 and change people are dying every year waiting for kidneys. There's been a movement, and then maybe Ilya might want to say something or not, to have organ markets, where instead of just waiting on a waiting list to die, you can pay for one. So before we get crazy, let's talk about Steve Jobs for a second. You know about this, Ilya? So he's being quiet, and he's usually not so quiet. Steve Jobs, you know, Mr. Apple, right? Billionaire. He had, was it a liver or kidney? I can't remember. It was a liver, right? Liver, right. So Steve Jobs was in desperate need for a liver. So what did he do? Well, you know, he lived in California. He registered on all 50 states' waiting lists. He actually bought homes, all 50 states, to register for every single state. He actually had in Tennessee the head of their nephrology department living in one of those homes. Shocker, he found a transplant within like 2 years. And he basically got on a private jet, flew straight to, I think it was Memphis or Nashville, can't remember, and got his kidney transplanted, or liver, whatever it was. Okay, so generally speaking, people who are well off early can find an organ. And if they can't, they'll go to, you know, Thailand or Malaysia, and they'll get one in some other country. Okay, the argument basically goes,
or Iran, where it's legal.
Or Iran, yes. See, now he talks.
It's the only place in the world that has a kidney, a living donor.
It's a little hard to fly there, though. Yes. So, what do you think about this idea of allowing people to sell their own organs? And let me preempt a lot of your criticisms. It'll be a regulated market, right? There'll be protections against fraud. There'll be protections against coercion. Maybe the government can even create a national registry to handle this. For example, there's a national bone marrow registry, right? There are different ways to donate this stuff in a somewhat safe manner. Okay, but the flip side is, once you give up a kidney, you can live a normal life for the most part. There might be some complications. You might die. Let me ask, raise of hands. How many people, if you were, and what about $20,000 about the market value? Give or take. So say 20 grand. That's like one semester worth of tuition. God. Talk about losing an arm and a leg, right? So, show of hands. Who here, if you were short on cash, would consider $20,000 in your pocket? 1, 2. For giving up your kidney. Wow. In the back, Troy, why would you be willing to give up 20 grand to pocket $20,000 easy for going through the surgery? You like to eat. Okay. Ashley? Shh. One at a time. Okay. Okay. Good. Okay, so she said one word, which was consent, right, which is an important issue here. Okay? The problem in the Moore case was there was no informed consent. They lied to him. The guy asked, are you using this for commercial purposes? He said, no. Okay, so they lied. So let's assume we have informed consent, right? If this is the case, it becomes a trickier call. So, okay, I want someone now who emphatically says no. And not just no for the monetary reasons, no for some sort of moral reasons. Who here, all right, Judson, let's say, morally, why would you not, or maybe not let it, if your family member said, hey, Justin, I really need the cash, I want to give my kidney, what would you tell that person? What? You can live with one. You don't need both of them. Well, okay, good. No. I see we're going. Flesh it out. What do you mean have for a reason?
Well, I mean, what if the other kid failed later on in your life and you did?
Okay. What else? What? Any religious objections? Yeah.
I kind of raised my hand before you said the word religion,
You can, okay, you can answer whatever you want.
Putting a price on what some people would regard as something that's God's creation.
Ah. Okay. So one interesting thing about Judaism, and not everyone practices this, but if you have an organ removed, you're supposed to be buried with it. It's kind of an odd thing, which perhaps most people don't practice. But the idea is from ashes to ashes, dust to dust, right? There is a moral conception that the way that the Almighty made you is the way that you should leave yourself. Perhaps giving up a body commoditizes that as well. Who else? Who else is morally opposed?
I'm not necessarily morally.
I'm not asking anyone else. I want to say a moral opposition to the organ markets. All right, Billy, give us the libertarian talking point on this. What's the argument in favor of organ markets?
Well, there's a shortage of organs. Why is that? Because the market's not operating to set a proper price. If you allow a market to operate, then supply will equilibrate with demand, and there will be overall Pareto optimality, benefit to those who get the organs, benefit to those who sell them.
Win-win.
The win-win.
It's a win-win.
As long as, again, with your stipulations that you control for fraud and coercion. And
all right, Chad?
Well, I'm just picking back off what Justin said. It's a very narrow-sided thing. So I'm going to get 20 grand today. Who's going to care for all these people who've given up part of the organs when they're 20 years from now, 10 years from now, when they start that problem? Right? So you have to take that into consideration.
Okay, all right. So I think
typically the contracts are made now when you donate free, they give you lifetime medical insurance.
All right. So I think what I'll summarize everything a little bit is a lot of the laws that we have are based on some notions of morality, and this case really drives from the point of who should be making these decisions, right? Should the courts be in the business of deciding these tough issues? Should the legislature? Alternatively, when someone already got screwed over like Mr. Moore, should the court step in and fix it? Which is also a somewhat touchy issue. All right? All right, so immediately after this, if you want to go up now, you can, in the 6th floor library. Ilya and I and others from Rocky Roads will be doing a Supreme Court roundup. There'll be lots of food, and I encourage you to come. If not, have a great, and I'll see you all on Monday. Thank you. Come here. Yeah? Say the world.
I didn't realize that you actually had integrated the organ thing into your class. I thought you were saying